As those of you who followed the Mills-McCartney divorce will know, the courts today encourage people, the family law courts encourage people to seek alternatives before they arrive in court. So the ideal in a divorce scenario is that the couple should have agreed the measures in advance, and that the court will simply confirm those measures, assuming that they are fair to both parties. It will review them and confirm them. In the family law setting, you can see where this would be advantageous. It means that it's less rancorous, it's less expensive, it doesn't take as long, but also it should mean that the family, because the couple, because they've agreed on the issues and they've discussed them themselves, rather than having them imposed from someone else, they should be more workable, and also hopefully they would be something that both parties, it might help to some kind of ongoing relationship that they might have vis-a-vis children, etc. So, alternative dispute resolution is used in civil law matters in a large number of cases. Wolf's review of the civil justice system Lord Wolf's review suggested that ADR should be employed in more and more cases, and since then ADR has been employed, and since its promotion, the number of cases going to court, civil law cases going to court, has been dramatically reduced. There's a lot of reasons why this is a good idea. If you think about what civil law is as opposed to criminal law, there is less of a public interest in civil law matters because it's obviously dealing with issues between private individuals. And so if they can come up with another means of resolving that dispute, then that can be a very positive mechanism for solving it. It's much cheaper than the courts, it's much more efficient, time efficient than the courts, and you can bring in experts, depending on the type of ADR which is being employed, who understand the industry that's being dealt with in particular. So in labour law disputes, etc., we've been using forms of alternative dispute resolution in labour law for many, many years, and quite successfully. So the final thing then that we can say about all forms of restorative justice, alternative dispute resolution, truth commissions, is that they are seeking non-court based solutions to legal problems. That's the thread that ties them all together. And the reason for that is that although lawyers tend to favour the courts as being a means of resolving disputes, the courts are not always the most efficient way of going about it. They're not efficient in terms of time, they're not efficient in terms of money, but also sometimes they don't actually get the result that we want. So when we spoke about restorative justice, we said that one of the problems with the court system, one of the problems which can be identified with the court system, is that it doesn't necessarily acknowledge the victim. The victim doesn't play a huge role in a court system. And often victims can feel a bit let down by the system. They can feel like they're ignored by it, and that their hurt isn't being taken into account. So with restorative justice, they are much more involved in the process, and that can help victims with the process of getting over what has happened to them, gaining some kind of closure on the event, etc. In the Truth Commission scenario, we spoke about the fact that when a state is in a nation-building situation, where it is trying to recover from something like the apartheid regime or in a post-conflict situation, then these other alternatives can be better and lead to less rancor and less discord, less dispute. They can be faster as well, and ultimately, although the Truth and Reconciliation Commission cost an awful lot of money, it's difficult to say whether it would have been cheaper to prosecute people. Many people would argue that it would not have been cheaper, but of course that was about much more than simply cost inefficiencies. So what we're talking about with all of these alternatives is trying to look at the system and trying to make the system work better in the particular circumstances that we're faced with. And that's why we have modified these systems over time. Lawyers can be suspicious of it, and the law, as it relates to having a fair hearing before a fair tribunal, etc., is sometimes uncomfortable with these types of these alternatives. Because they are not court-based, they don't fit easily within a legal system which is developed with courts at its core. And so the challenge going forward for all forms of alternatives is to see how we can make them tie in with the legal system so that they respect human rights, so that they respect the traditions that we understand within the law, and yet not make them so much like a court that they lose all of the efficiencies that are gained by having them in the first place. One of the interesting developments that's happened in recent years is that tribunals, public law tribunals, dealing with mental health issues, dealing with employment issues, etc. Increasingly, solicitors and barristers are appearing on behalf of parties at tribunals. Now, the point of tribunals was that they were supposed to be less like courts and more efficient because they involved experts in the area, etc., who were able to hear the cases. And so they should be more efficient, better able to deal with those cases. But the more you involve lawyers in the process, the more like a court procedure it becomes, the less flexible and the less alternative it is. If it starts to act, look, and behave like a court, then it loses those efficiencies which attracted us to the idea in the first place. And so we need to try and get this balance right when moving forward with alternatives, that they respect human rights and civil liberties and the legal system within which we operate, but at the same time, that they retain that flexibility, etc. Okay, despite that stutter at the end, I'm going to call it a day here. I wish you all the best, and I hope that you enjoyed this little experiment over this week. Take care, bye.